Based on her conduct in Ross versus Lockheed, I strongly believe that Circuit Judge Ketanji Brown Jackson should not be appointed by you as the first Black female justice of the Supreme Court of the United States. The Ross case was brought as a 2016 class action on behalf of 5,500 Black workers of Lockheed Martin Corporation, the nation's largest federal contractor. Before filing the lawsuit, lawyers for the Black plaintiffs negotiated a settlement with Lockheed Martin, which provided for a reformed evaluation system, the cornerstone of pay and promotion decisions, and $22 million to be distributed to the Black workers. When the lawyers presented the settlement to Judge Jackson, she incredibly refused to approve the settlement because, in her view, there were no common factual questions. Then, more incredibly, she denied the plaintiff their fundamental right to take discovery of Lockheed Martin's books and records as they sought to prove class action status. Finally, by taking 54 days to issue her memorandum opinion accompanying her order denying class certification, she effectively aborted plaintiffs' rights to appeal her class certification decision under Rule 23F of the Federal Rules of Civil Procedure. So Judge Jackson in Ross, 1, gave the axe to a settlement designed to benefit numerous Black workers at one of the nation's largest employers. 2, denied the injunctive relief agreed to by Lockheed Martin that would have addressed a root cause of systemic racial bias that could have been a model for a nation hungry for racial equity solutions. 3, denied the Black workers the right to seek evidence to prove their claim of company-wide racial discrimination. And 4, knowingly frustrated the rights of Black workers to appeal her decision.
As you said, the guideline was based originally on a statutory scheme and on directives, specific directives by Congress at a time in which more serious child pornography offenders were identified based on the volume, based on the number of photographs that they received in the mail. And that made total sense before, when we didn't have the internet, when we didn't have distribution. But the way that the guideline is now structured, based on that set of circumstances, is leading to extreme disparities in the system because it's so easy for people to get volumes of this kind of material now by computers. So it's not doing the work of differentiating who is a more serious offender in the way that it used to. So the commission has taken that into account, and perhaps even more importantly, courts are adjusting their sentences in order to account for the changed circumstances.
Can I just add one point about these kiddie porn cases? And this came up, I remember, when I was an assistant U.S. attorney back in the 90s, is that when those sentencing guidelines were written for those cases, this was a time when the people who committed these crimes would order individual photos and then get them usually through email. And then they would be sentenced based on the number of photos they possessed. This was all pre-internet. So once the internet came in and people got access to hundreds and then thousands of photos, the sentencing guidelines would reflect hundreds and then thousands of photos. Federal judges have been struggling with the issue of how do you create a fair system that was designed pre-internet, that was, yet you have to sentence people post-internet. And what I thought Chairman Durbin pointed out is that judges across the country, including Republican-appointed judges, have been saying, look, we can't apply the rules that were designed pre-internet for an internet society, and many judges have been giving somewhat less sentences as a result. And I thought that was a very clear explanation of why Judge Jackson imposed sentences that were all prison sentences. It wasn't like she was letting these people go, but they were somewhat less than the guidelines because the guidelines had not been adapted for the internet